Unacademy. Let's crack it.
हेलो एंड नमस्कार, मैं हूं तनसुख पालीवाल। किसी भी जुडिशियल एग्जाम की मॉक इंटरव्यू या इंटरव्यू ओरिएंटेशन जो सेशन होते हैं, इंटरव्यू ट्रेनिंग सेशन जो होते हैं, जब आप उनको ऑब्जर्व करते हैं तो आप रियलिटी के अंदर किसी कैंडिडेट की परफॉर्मेंस को ऑब्जर्व करते हैं और वहाँ पर आप उनके प्लस और माइनस पॉइंट्स को भी देखते हैं कि कहाँ पर उस कैंडिडेट ने गलती की है, कहाँ पर उस कैंडिडेट का जवाब अच्छा रहा है। तो बोनाफाइड पर्पस को ध्यान में रखते हुए आप सभी लॉ एस्पिरेंट के बेनिफिट के लिए ये वीडियो अभी आपके सामने स्ट्रीम होने वाला है। लेकिन इससे पहले ये वीडियो स्टार्ट हो, मैं चाहता हूं कि आप पेपर और पेन लेकर जरूर बैठें और जो जो चीज़ें आपको लगता है कि आपको सीखनी चाहिए, आपको रेक्टिफाई करनी चाहिए खुद के केस में, उनको नोट डाउन ज़रूर करें ताकि लिंकिंग लॉस का ये जो पर्पस है वो अपने आप में फुलफिल हो सके। आई होप आप इस वीडियो को जो है बेहतरीन तरीके से अपनी प्रिपरेशन में इस्तेमाल करेंगे, अप्लाई करेंगे। सो लेट स्टार्ट दिस स्पेसिफिक इंटरव्यू ट्रेनिंग एंड ओरिएंटेशन। वेरी गुड आफ्टरनून। Briefly introduce me with your academic and other achievements.
Sir, my name is Ritiz Arora. I was born and brought up at Haryana in Punjab. From there, I have done my high schooling as well. And sir, I did my bachelor's in law from Punjabi University, Patiala. And presently, sir, I am pursuing my master's from Kurukshetra University.
So you have good command over Punjabi?
Yes, sir, to an extent.
There is any role of Punjabi in the Haryana judiciary?
Sir, no, sir, because sir, but the cultures and the languages, with respect to Hindi, sir, they are almost same, sir. So I'll be able to interact in Hindi as well, sir.
Suppose the language of court is differ than Punjabi or the other language, and the accused person is find himself unable to understand the proceeding of the court.
Sir,
Now, as a presiding officer, what stand can you take?
sir, as a presiding officer, I can take the help of the interpreter in such cases.
Interpreter.
Yes, sir.
Interpreter is liable to be interpret truthfully where it has been mentioned.
Yes, sir. It has been mentioned in the Indian Evidence Act.
Indian Evidence Act or Criminal Procedure Code?
Sir, it has been mentioned in both, and if he willfully disobeys such orders, sir, then he shall be liable to be prosecuted under Section 166 of the Indian Penal Code.
Oh, so Indian Evidence Act, when it is effective?
Sorry, sir?
When the Indian Evidence Act was effective?
Yes, sir. It came into force on 1st September 1872.
Okay. Before that, any evidence law is there in India?
Sir, I'm not aware. I'm sorry.
Indian Evidence Act is effective from September 1872, which is a pre-constitutional date, right? So how it is still working? Any special provision in this regards by virtue of which it is still working?
Yes, sir. So there's a provision in the Indian Constitution, Article 13. Sir, it provides that. Yes, sir. So it provides that all the three constitutional laws which are not in infringement with the fundamental rights enshrined under Part 3 of the Constitution, so they shall be effective, sir.
Don't you think that you have reversed the language of Article 13?
I'm sorry, I'm not aware if I did so, but I think so, sir, the practice like that.
Okay. Let me know if a special court want to punish a particular person and the same person is liable for the same offense under CRPC, then which stand will be overriding? CRPC or the act, the order of a special court?
If a special court has been enacted under a specific act, specific statute, then the special law will prevail over the general law.
So the order of special court will survive.
Yes, sir.
Okay. So now I'm giving you a special situation. Negotiable Instrument Act. Have you heard about it?
Yes, sir.
When a check is dishonored, a complaint can be lodged under 138 sections. Okay.
Yes, sir.
A person who has given a loan of rupees 5 lakh to Mr. B,
Sir.
and after the due period, Mr. B has returned the payment by a check, and the check got dishonored. That
Sir.
person has filed a complaint of 138. Now that person also want to file an FIR under section 420 Indian Penal Code
Yes, sir.
for cheating and fraudulent delivery of the property. Whether he can do so legally.
Sir, in my opinion, sir, he can do so because these both are distinct remedies. Uh, I think so, sir, he can do so. I'm not sure, sir.
No, it's remedy or it's framing charge.
Sir, if sir, at the time of sir filing the complaint for the dishonor of trust, the complainant seeks the permission of the court. He can, he can amalgamate both the cases, whether it is cheating and the dishonor of trust. But sir, after the conviction is there in the Negotiable Instrument Act, after that, the double jeopardy rule will apply.
You have mentioned the double jeopardy rules. Autary fees acquit and autary fees convict.
Sir.
Both terms has been covered in double jeopardy or not?
Sir, under the Constitution, only the previous conviction is covered, but under the Code of Criminal Procedure, so both the terms are covered under Section 300.
Legal ad. This is the terminology in the CR. In a judicial magistrate court, an accused person does not have sufficient means to engage a lawyer for his defense. Whether the court of magistrate can grant him legal aid by virtue of 304.
No, the Court of Session has the power under Section 302.
Court of session. Any provision by which judicial magistrate can have also same power?
But I think that the Legal Services Authorities Act that can be made applicable, or the constitutional provision under Article 39A can also be made applicable.
No, my question is that there is any way by which the power which is used by the session court, legal aid, can also be used by judicial magistrate. There is any provision in this regards, any manner, any way?
But I'm not sure, but sir, Legal Services Authorities Act 1987 may be applicable in this case.
What exactly word has been used under section 89 CPC? Settlement or judicial settlement?
The judicial settlement.
Judicial settlement. What is difference between these two terminology?
Settlement can be made outside the court as well. However, judicial settlement, sir, this is backed up by certain authoritativeness. For instance, sir, in Lok Adalat, sir, the judicial settlement may be offered. This much I am aware of.
Compromise decree can be appealed.
Sir, no appeal against consent decree.
Where is such bar?
Sir, Section 96 of the Code of Civic.
Okay. Power of appellant court in CRPC, where it has been mentioned.
Power of appellate court, sir, Section 396.
396.
Yes, sir.
Then reference and revision, where it has been mentioned.
The reference has been mentioned in section 394, sir, and revision has been mentioned that from section 397 only.
Under section 32, two authority has to give power, to confer power to the lower court or any person. Which are these two authority under section 32?
32 of the Code of Criminal Procedure, sir?
Yes.
Sir, I'm sorry, I'm not aware.
You are not aware. Okay. One court is missing, which is there in section 6 CRPC, but not in section 26 CRPC.
Yes, sir.
Which one is that court?
I think it is the executive court. I'm not sure. Sir, if I'm able to recall for a few seconds, sir. Yes, sir. Sir, I think that sir, executive court is not mentioned, I think, in section 6. I'm not sure. Not able to recall the provision.
Okay. On highway during sunset and sunrise, between sunset and sunrise, A robbery was committed,
Yes, sir.
for which a rigorous imprisonment for 14 years has been provided as a sentence. Now, which court can try this offense?
So as a general rule, I am aware that the robbery offence is triable by the judicial magistrate of first class, even if the punishment extends to imprisonment for life. So I think in this case also judicial magistrate.
Now, suppose at the end of the trial, the magistrate think that I am not competent to give such sentence, then what he can do?
Sir, if he sometimes that he is willing to give that extends to 7 years, sir, then he can submit the case to the Honorable Chief Judicial Magistrate, sir, under Section 325. And if
And
more
hmm,
7 years, then he can commit post trial, sir, under Section 323.
320?
323, sir.
So 323 will be post trial or during trial?
Sir, during trial, I'm sorry.
During trial. Okay, and 325 is during trial or post trial?
Sir, it is also during trial.
So both are during trial?
Uh, Yes, I think so. Sir, during trial also, sir, post trial even at the judgment stage can also be committed and submitted.
Now, suppose under section 325, the CGM want to deal directly with the hearing of sentence. He can do so.
Yes, sir. The
He can do
honorable,
so.
yes, sir.
Hearing of sentence.
Hearing and so yes, he can do so, and he can independently apply his mind on the quantum of sentence.
So can I say that when 325 is applicable, the judicial magistrate will pass a judgment of conviction but accept the hearing of sentence?
Sorry, sir. I'm not able to
Can we say that by virtue of 325, a judicial magistrate will pass a judgment of conviction, accept the hearing of sentence, and hearing of sentence will be dealt by the CGM? Can we say that?
the hearing of the sentence can be dealt with by the Honorable CGM or the Honorable Court of Sessions, sir. The conviction can be passed by the judicial magistrate of first class.
Okay. In criminal procedure code, there is a provision as to language of the court. Which section dealing with it?
But I think it is section 272, sir. I'm not sure, sir. It is actually section 272.
Whether you are a male, since you are a male presiding officer, okay,
Sir.
a particular case of rape victim has been there
Sir.
now, and you have the choice to send it to a female presiding officer,
Sir.
but you want to hear that matter,
Sir.
and you call that girl in your chamber.
Yes, sir.
Okay, now that girl want to lodge a complaint against you for misbehaving. As a judicial officer, what will be your stand?
Sir, after the 2008 Criminal Law Amendment Act, there was a provision which was added in the code, sir, which provided that in rape cases, sir, the trial shall be held as far as possible by the women presiding officer. Sir, so as far as time is used in that, so if a women presiding officer is not available, sir, I have the authority to conduct the trial. But I think that in such cases, the consent of a victim, sir, it must be obtained mandatorily. And if in such case, sir, any of the proceedings, such if files a lodges a complaint against me or any of the proceedings, sir, I will be providing this reason that I have not misbehaved since it it was a trial like open court, sir. So there was no misbehavior in the matter.
Why do you think that you be chosen as a judge?
Think that I should be taken as a judge. First one is, sir, that I have the sense of perseverance in me, which I think, sir, it should be there to decide to hear the matter courteously, sir. So secondly, I think that I am honest in my thought process, and that is one of the qualities a judge should have to decide the matters impartially, sir. And apart from that, sir, I think that I am a hardworking kind of a person. That is me, sir.
You have said that you are an honest person.
Right.
How do you came to know?
Sir, with my peers and my family, sir, they always say that you never feel like it.
Your families and all now.
Yes, sir.
Your families and all are the interested witness.
Yes.
They certainly will talk about in your favor only. Then
So, but I think that I am honest in my TOEFL. That is reflected from my accent, sir. Whatever I say, whatever I speak, it's a sir. Whenever
you have any document which saying that you are an honest person?
no, sir, I don't have that. But I from internally, sir, my thought process is honest, and that I am aware of.
No. If suppose in your court,
Sir,
a person is making his defense and he
sir,
produce his brother, sister, mother, father as a witness,
sir.
and they say that now my child is totally innocent, he has not committed any offense, will you rely on that on their statement? No.
Sir, but
Then
in justice,
how can in your life you can rely on the statement of your family?
indeed, sir. So
Is it
no,
impartial view or is it a partial view?
sir, yes. Sir, no doubt, if we speak technically, they are interested people. But sir, as the Honorable Supreme Court has said that testimony of interested witness, sir, it shall not be rejected in total, sir. So I
I'm just
think that
interested to know that how do you came to know that you are an honest person? What are the logic behind it that you have thumbs up this quality with your personality?
sir, whenever I go, I speak to my accent, sir. And I think, sir, I developed a balance, a rational view before getting
No,
onto any.
that's your intelligence that you are doing a rational view. But we are
Sir,
talking about the honesty.
yes, sir.
Honesty totally different from the rationality, yes or no?
Sir, yes, sir. Right, sir. Sir, I
Okay,
think
stay
on.
connected. Stay connected. I will get back to you for your feedback. Thank you.
Thank you.
Yes, Mr. Arora ji, what's your full name? नाम क्या था पूरा आपका?
Arora. Ritiz
हम्म?
Arora. Ritiz Arora, sir.
रितेश अरोड़ा जी। हमेशा ध्यान रखना, जब भी अपन नाम को इंट्रोड्यूस करते हैं, खास कर जो ई से साउंड करने वाले नाम होते हैं, अल्फाबेट्स होते हैं, जब भी आप अपने नाम को इंट्रोड्यूस करते हैं, इस केस में अगर आपका नाम फर्स्ट नेम अगर सुनाई नहीं दे, थोड़ा सा उसको लाउड रखें, स्लो रखें, ताकि सामने वाला को सुन पाए। फर्स्ट थिंग,
Okay.
देखो मैं आपको फास्ट फीडबैक दूंगा, आई एम नॉट इंटरेस्टेड इन योर पॉजिटिव फीडबैक, क्योंकि वो
Right.
आपको आपके पर्सनालिटी से पता चल गया होगा। सबसे पहले हमेशा एक इलस्ट्रेशन अपने पास में रखा करो अपनी पर्सनालिटी की फीचर के संबंध में। जैसे जब मैंने
Okay.
आपसे ऑनेस्टी के बारे में जानना चाहा, तो यू आर टोटली फेल्ड इन दैट रेस्पेक्ट। आपने
Okay.
खुद ने इस बात को रियलाइज किया होगा कि आप इसको प्रूफ नहीं कर पाए। आपने स्टेटमेंट कह तो दिया आई एम ए ऑनेस्ट पर्सन, बट आप इसको प्रूफ नहीं कर पाए। तो इसका आंसर क्या है, सॉल्यूशन क्या है? एक अपनी लाइफ का कोई रियल टाइम इंसिडेंट बोर्ड से परमिशन मांगो कि सर इफ यू अलाउ मी देन आई वुड लाइक टू इलस्ट्रेट बिफोर यू वन इंसिडेंट ऑफ माय लाइफ एंड ऑन द बेसिस ऑफ व्हिच आई कैन से दैट आई एम एन ऑनेस्ट पर्सन। ऑनेस्टी का मतलब क्या है? आपके अंदर किसी और का लालच नहीं आता है ना, यू आर नॉट ग्रीडी। उसका एग्जाम्पल दो कुछ इस तरीके से, लाइक आपको किसी का कोई वॉलेट मिल गया, उस तरीके से आपने आईडी कार्ड मिल गया तो आपने आइडेंटिफाई कर फाइंड आउट किया है ना, तो उसका आपको ऐसा लगा वगैरह। फैमिली के एग्जाम्पल देना, फैमिली के एग्जाम्पल तो इंटरेस्टेड पार्टीज है, फैमिली तो हमेशा कहेगी यू आर अच्छे हो, आप अच्छे बच्चे हो ना, वो तो हमेशा यही कहेगी, राइट। सो आपकी जो भी पर्सनल ट्रेट्स है, पर्सनल स्ट्रेंथ है, उनको आप क्या करें, बकायदा इलस्ट्रेट के साथ में एक्सप्लेन करें, अगर रिक्वायरमेंट हो तो, जब आपसे ऐसा पूछा जाए। देयर विल बी मेनी थिंग्स, okay, so first work on that. Every strength must have at least one illustration of your life.
Okay,
First
sir.
thing. Second thing, you made sections error repetitively. When I ask you for the power of appellant code, you mentioned 396. Actually, you forgot the range of the chapter as well as.
It was
Reference and revision are dealing with 395 to 405. Reference and revision. And not only one time. Power of appellant code 386 dealing with. Reference has been mentioned in 395 following 396. Okay. But mismatch, you have mentioned the reference in 394, then revision in 396. So each and every section is got puzzled.
right.
Totally mistaken. Then if you want, take your time. Don't be extra hectic in giving the answer. Just think about it. If you want to recall, then recall it. When the interview date is there?
The 17th September.
It's 17 now. You have at least 20 days.
Yes, sir.
And these 20 days really require your better revision.
Yes,
Do
sir.
proper meditation, stand before the charts if you have linking charts, etc. Something if you have, then stand before them for 2 hours, 3 hours, 4 hours, and just give a thorough look of all these. Range must not be missing, especially in the major law. Okay, chapter range must be. हमारा आंसर अगर सेक्शन उसी चैप्टर में कोई दूसरा बता रहे चलेगा, बट आप दूसरे चैप्टर में चले गए तो ये गड़बड़ है, ये नहीं चलेगा. Okay.
And the
Further, जब आपसे मैंने ये पूछा कि इंडियन एविडेंस एक्ट 1872 का अभी तक कैसे चल रहा है, आपने आर्टिकल 13 का एक्सप्लेन किया. आर्टिकल 13 इज द प्रोटेक्टर ऑफ पार्ट थर्ड. If the things are violative, then what will they do? They will cut it as unconstitutional by doctrine of eclipse or doctrine of severability. But Article 372, the word as you mentioned, existing law, by virtue of which IPC 1860, Indian Evidence Act 1872, CPC 1908, all are surviving. Article 372, that is the main provision. 372 हमारे सिलेबस का जो पार्ट है वो हमें पता होना चाहिए कि वो क्यों है वहां पे. Okay, 420 or 138, your answer is correct, but I think you should support it with the landmark judgment of Sangeeta Ben Mahendra Bhai Patel versus State of Gujarat, where it has been mentioned if the two offenses have different ingredients and ingredients of both offenses have been satisfied, then two separate proceedings can be done. Complaint under 138 and FIR under 420, it can be done. Sangeeta Ben Mahendra Bhai Patel, State of Gujarat. Okay. Judicial settlement versus settlement. Settlement include judicial settlement or non-judicial settlement. Confession can be judicial confession or extrajudicial confession. Settlement can be judicial settlement or extrajudicial settlement. So your answer is correct. The judicial settlement word has been used under section 89. But when we are going to the difference, you said, sir, judicial settlement is so and so and settlement is so and so. No, settlement is the common word which includes judicial as well as extrajudicial. These things show your concept about your command over the words, selection of the words, which must be absolute, which must be specific. Work on that. As far as your positive things are concerned, you are very polite, smiling person. Your voice is quite humble. Your dressing sense is okay. Everything is perfect. But the main thing is legal concept, and you need to work on that. अरोड़ा सर, अभी ये जो अगले 20 दिन है, जान झोंक दो इसके अंदर. समुद्र पूरा तैर के यहाँ तक आए हैं आप. एक छलांग लगानी है किनारे को पार लगाने के लिए. अगर आपके पास लिंकिंग चार्ट्स नहीं है तो मंगवा लो, दीवारों पे चिपका लो और मेडिटेशन करो, खो जाओ उसके अंदर, क्योंकि वो अगर दिमाग में होगा तो उसमें आंसर भी निकलेगा. जस्ट विश यू ऑल द वेरी बेस्ट.
Thank you, sir.